Hello and welcome to this meeting of Assembly Committee on Education for the 2023 legislative session. Secretary, will you please call the roll?
Assemblywoman Anderson. Present. Assemblyman De Silva. Here. Assemblywoman Hanson. Here. Assemblywoman Hardy. Assemblyman Koenig. Here. Assemblywoman LaRue Hatch. Assemblyman MacArthur. Here. Assemblywoman Mosca. Here. Assemblywoman Taylor. Present. Assemblywoman Thomas. Here. Assemblywoman Torres. Here. Chair Bill Brax.
And I am here. Welcome to everyone here in Carson City, those joining by video in Las Vegas. Just some housekeeping, make sure you turn down your electronic devices. And if you, well, actually, we won't have any testimony unless we call you up for a work session question from a member. We do expect courtesy and respect, as we all know. With that, let's get started. Today we'll conduct a work session to take action on measures the committee has heard in previous meetings. It's not customary for the committee to take testimony or otherwise rehear the bill, but we may have some comments on the record or pull up senators and the like if the committee does have specific questions. We will be work sessioning 9 bills. So we will start with AB 97, and I will turn it over to my policy analyst, Alec Drozdoff. 497, I don't know what I said, but AB 497, 497, thank you.
Thank you, Chair Alex Drozdoff, Committee Policy Analyst. For the record, as nonpartisan staff, I cannot advocate for or against any measure. The first bill on work session is Assembly Bill 497, which revises provisions relating to education. The committee heard this measure on May 16th. Assembly Bill 497 authorizes a pupil to attend a public school outside the zone of attendance the pupil would otherwise be required to attend if that school is not at capacity in the grade or classes required by the pupil. The bill further requires the superintendent of each school district to establish an application process to enable such pupil transfers and outline certain details of the process. Finally, the bill specifies that a board of trustees that furnishes certain pupil transportation may elect not to provide transportation to pupils who attend a public school outside the pupil zone of attendance. Assemblywoman Bilbray Axelrod submitted an amendment clarifying that the State Board of Education will oversee the application and open enrollment plans established by the school district. Additionally, the Assemblywoman proposed an amendment specifying that school districts may accept gifts and grants to carry out the provisions of this bill. Additionally, the proposed amendment adds Assemblywoman Mosca and Assemblywoman Hanson as co-sponsors. Thank you, Chair.
Thank you very much. I take a motion. No, sorry. I'm trying to do like 5 things at once. Any comments? Yes, Assemblywoman Anderson.
It's all good. Thank you, Chair, and thank you for the explanation about that as well. I greatly appreciate the conversations that we had yesterday about the concerns I had, especially with a brand new superintendent coming to the district that my district is in. And so I was under the impression that there would also be a date change, that it would not actually be implemented, or clarification. The date of implementation of filing of those plans would not be until January of 2025 to give our superintendent some time to be able to make those changes. So then that way this idea would not be in implementation until the 2025-26 school year. So just wanted to ask that, if that was still being a consideration, or how you wanted to exactly deal with the date of implementation question.
Thank you, and that will be on there as well. It is moving to January 1st, 2025, and I'm sorry that was not on the work session document, but that is the intent, and I consider that part of the motion when we get that motion. So with that, do I have a motion to amend a new pass? First, we have Assemblywoman Hanson and a second from Assemblywoman Torres. Are there any comments? Yes, Assemblywoman Mosca.
Thank you, Chair. Thank you for adding me as a co-sponsor on this bill. I think this is a really important bill to ensure all of our students and families have access, and I'm very excited for it. Thank you.
Thank you. And with that, I will take a vote. Oh, I'm sorry. Apologize. Assemblywoman LaRue Hatch.
Thank you, Chair. I just wanted to say I really support the idea behind this. I still have some questions about how we're determining the max capacity and the transportation to make sure this is truly equitable. So I'm going to be a no today, but I'm going to continue to work to hopefully figure those out so that I can get to a yes.
Vice Chair Taylor.
Thank you, Madam Chair. And I too will be a no today. And my concerns, I voiced a little bit when we had the hearing, is around the equity issues and everyone really having the opportunity to get to other schools, and hopefully transportation will come. But then with transportation, you don't have the same opportunities for extracurricular activities because you can't go home, you can't get home, and so on. So I'm still a little troubled by the equity piece of it. So I'm a no on it for now. Thank you.
Thank you. With that, any other comments? Okay. All in favor say aye. Aye. Those opposed say nay.
Nay.
And that was Vice Chair Taylor and Assemblywoman LaRue Hatch. Motion carries. And I will assign that floor statement to Assemblywoman Mosca. Second bill up for work session is Senate Bill 80. And I will turn it over to Ms. Drozdoff.
Thank you, Chair. The next bill on work session is Senate Bill 80, which revises provisions relating to the prevention and treatment of injuries to the head. The committee heard this measure on May 4th. Senate Bill 80 expands the policies adopted by the NIAA and organizations for youth sports concerning the prevention and treatment of injuries to the head. The bill also requires a policy to include certain steps a pupil who sustained or is suspected to have sustained an injury to the head is required to complete in order to return to school or interscholastic activity. Additionally, SB 80 requires the Board of Trustees of each school district and the governing body of each charter school, university school for profoundly gifted pupils, and private school to adopt such a policy and create and distribute a brochure concerning the prevention and treatment of injuries to the head. Public and private schools must establish a concussion management team to perform certain duties prescribed in the policy, and certain school employees must complete training related to head injuries. Finally, SB 80 provides that a person who willfully fails to perform the duties outlined in the bill is guilty of a misdemeanor. Assemblywoman Howdiggy and Youth Legislator Thornton submitted an amendment that makes several changes, including adding legislative declarations, deleting sections 1 through 6 of the bill, directing the NIAA, the Superintendent of Public Instruction, and the Chief Medical Officer to adopt regulations prescribing a policy related to injuries of the head and outline certain details concerning the policy. Specifically, an amendment was proposed to specify that the NIAA will be adopting policies relating to return to play in consultation with the Superintendent and Chief Medical Officer. Policies on return to learn will be adopted by the Superintendent in consultation with the NIAA and Chief Medical Officer. Additionally, the proposed amendment removes language relating to the concussion management team. Finally, an additional change was proposed to the amendment in regard to language concerning training. The proposed change is to adjust the language concerning an employee of a public or private school who is reasonably likely to encounter a pupil to instead refer to an employee of a public or private school who supports students' academics, health, or mental health. Thank you, Chair.
Thank you. And members, are there any questions? Assemblywoman Anderson.
Thank you, Chair. And I again want to just say how impressed I was with Youth Legislator Thornton's presentation, and then also the amount of time that she spent, I believe, after the hearing trying to meet with us and get the language together. My question has to do with the amendment number 2, and if there could be some clarifications of who those individuals who would be that support students' academics, health, and mental health, and if that would be defined in regulations, or if that would be defined here legally, or how exactly that would be defined.
Thank you, Assemblywoman Member. Mr. Killian?
Thank you, Madam Chair. Asher Killian, Committee Counsel. So this is language that would be implemented by the school districts. Generally, the language refers to employees who support the academics, health, or mental health of pupils. So generally, that would be people like teachers, counselors, social workers, school nurse, et cetera. As to which particular employees are appropriate for that category in each school district, the bill would provide general guidance and leave it to each school district to implement the specifics of which particular employees fall into that category within that particular school district.
Members, any other questions? Okay, with that, I will take a motion to amend and do pass. Assemblywoman, or Vice Chair Taylor has made the motion, a second from Assemblywoman Torres. Any discussion of the motion? Assemblywoman Hardy.
Thank you, Chair. And I too just want to again tell Ms. Thornton what a wonderful job she did, and she got the full experience here of taking a bill like we all do and going through the parts that, you know, people didn't feel comfortable with and amending and so forth. I'm going to be a no right now because I want to just go through this amendment a little bit more thoroughly and understand it and make sure some of the concerns that I had were addressed. But I do just want to commend you for the work that you did and for the majority leader assisting you. Thank you.
Thank you. And with that, all in favor say aye. Aye. All opposed say nay. And could you raise your hands, the nays? We've got Assemblywoman Hanson, Koenig, MacArthur, and Hardy as a no. With that, motion carries. Yes, and Assemblywoman, or Vice Chair Taylor has asked for the floor statement.
I know her grandmothers.
Because she knows her grandmothers. Okay, thank you. I guess so. You have to know a legacy. Hey, if any of you guys want a floor statement, you just let me know, and I'm happy to do it. Otherwise, they're all going to MacArthur. Next bill we have on work session is Senate Bill 114. Ms. Drozdoff.
Thank you, Chair. The next bill on work session is Senate Bill 114, which revises provisions governing the NIAA. The committee heard this measure on May 2nd. Senate Bill 114 provides that a pupil who transfers to a charter school or school that uses a lottery system to enroll pupils is immediately eligible to participate and practice in any sanctioned sport or other interscholastic activity or event at the school. A pupil who transfers from one school to another school may, not more than once in his or her lifetime, elect to be immediately eligible. The bill also prohibits school districts, public schools, and private schools from making regulations, rules, policies, procedures, or requirements concerning the eligibility and participation of these pupils that are more restrictive than provisions prescribed by the NIAA. Additionally, SB 114 prohibits the NIAA from penalizing, retaliating against, or taking adverse action against any school or person for participating in a legislative process or advocating for or against any policy before a public body. The bill also allows a person or school to appeal a decision by the NIAA to the State Board of Education. Senator Flores proposed an amendment deleting subsections 2B and 2C of Section 1.5 and the similar language in subsections 1 and 2 of Section 2. The amendment would also revise the language in subsection 3 of Section 1.5 to only provide a one-time transfer with immediate eligibility if the pupil is transferring between rather than within types of schools. Thank you, Chair.
Thank you, Ms. Drozdoff. And I, even though he is not here, I would like to thank Senator Flores for his work on this bill. I think with the amendment, it is good policy. Are there any questions from the members? Seeing none, I would take a motion to amend and do pass. Assemblywoman Thomas has made the motion. Do I have a second? Second. Second from Assemblywoman Torres. Any discussion on the motion? All in favor say aye. Aye. Those opposed say nay. Nay. Raise your hands if you would. We have Vice Chair Taylor, Assemblywoman LaRue Hatch, Assemblyman Koenig, and Assemblywoman Anderson, but motion does carry. I will give that floor statement to Assemblyman MacArthur. It's one of my favorite things I get to do. All right, with that, we'll go on to Senate Bill 148.
Thank you, Chair. The next bill on work session is Senate Bill 148, which revises provisions relating to local school precincts. The committee heard this measure on May 9th. Senate Bill 148 prohibits a local school precinct from employing a person to carry out any responsibility that has not been transferred to the local school precinct from a large school district. Furthermore, a local school precinct must meet certain personnel ratios when hiring certain school support staff to the extent that such staff is available, and the precinct may use carried forward year-end balances under certain circumstances to employ personnel necessary to meet such ratios. Additionally, SB 148 requires the principal of a local school precinct to select certain employees in accordance with any applicable collective bargaining agreement. A superintendent making any decision regarding the assignment or reassignment of staff from the large school district to the local school precinct must first consult with the principal of the local school precinct and the school associate superintendent. No amendments were proposed for this measure. Thank you, Chair.
Thank you. Members, do we have any questions? Seeing none, I will entertain a motion to do pass. Assemblywoman Anderson has made the motion, and second by Assemblywoman Torres. Any questions on the motion? Comments on the motion? Nope. Seeing none, all in favor say aye. Aye. Those opposed say nay. Nay. Okay, raise your hand. We have nays from Assemblywoman Hanson, Koenig, MacArthur, and Hardy. Motion carries. And I will assign that floor statement to Assemblywoman Anderson. Thank you. You're welcome. Next item on work session is Assembly Bill 196. Ms. Drozdoff.
Thank you, Chair. The next bill on work session is Senate Bill 196, which revises provisions relating to interscholastic activities and events. The committee heard this measure on May 4th. Senate Bill 196 codifies into law an existing regulation prohibiting a coach, manager, or other person associated with a sanctioned sport or spirit squad at a school from making a pupil's participation in an out-of-school activity a condition for qualifying for or becoming a member of a team. Additionally, SB 196 requires each such coach, manager, or other person to submit an annual report to the NIAA with information on whether the person also coaches, manages, or is otherwise associated with an out-of-school activity related to the same sport or spirit squad with which they are involved at a school. The bill also requires notification to pupils and their parents or legal guardians concerning the rights afforded to pupils while participating in a sanctioned sport or other interscholastic activity or event. The association must prescribe a system of progressive discipline for violations of these reporting and notification requirements. Finally, SB 196 provides additional eligibility for pupils enrolled in certain grades during the COVID-19 pandemic state of emergency to participate in certain interscholastic activities. Senator Hammond proposed an amendment to limit the pupils who can participate in a fifth year of high school athletics for the limited period of time specified in Section 7 to only those pupils who have not yet completed enough credits to graduate. Thank you, Chair.
Thank you, Ms. Drozdoff. Members, are there any questions? I just would like to get on the record, if you would, Mr. Killian, on what students in particular would be eligible for that extra year.
Thank you, Madam Chair, Asher Killian, Committee Counsel. So with the particular dates described in the bill, and with the effective date of the bill being July 1st, 2023, the only categories of pupils who would be eligible for the additional participation described in Section 7 of the bill as written would effectively be pupils who are rising juniors or rising seniors currently, so who will be juniors or seniors next year. With the amendment described in the work session document, that group of people would be further limited to only the pupils who are rising juniors or rising seniors and come back for an additional semester or 2 semesters of school after the end of their senior year because they still do not have enough credits to graduate. If one of those pupils wished to come back because of learning loss but still had a sufficient number of credits to graduate, if the school district allows them to come back, they could still come back for classes to address the learning loss, but they would not be eligible to participate in sports if they could graduate and chose not to.
Thank you for that clarification. Now we have comments. I opened the can of worms. Yes, Assemblyman Koenig, please.
I like the first half of the bill more than I dislike the second half of the bill, so I will be a yes.
That's fine. Next, Assemblywoman or Vice Chair Taylor.
Thank you, Madam Chair. I might have to think about that comment from my colleague there for a moment. But I was under the understanding, and perhaps the senator might be able to help that, if there are students that are seniors right now and met the criteria, they would still be, that was going to be an amendment you were going to consider, because it seems unfair, because they were also impacted by that. This is about losing your year during COVID. And it seems unfair in the event that there is a student right now that person would not be able to. So I don't know if the amendment allows for that, or, please.
Thank you, Madam Chair. Asher Killian, Committee Counsel. And I apologize, I left that out of my description. If there is a pupil who completed their senior year this year and still does not have enough credits to graduate and would be coming back in the fall of '23 because they require additional credits to graduate, that person would be eligible to play sports under this bill. It's only the people who would be coming back in fall of 2023 who could have graduated but chose not to, that would not be eligible to participate.
Thank you, Mr. Killian. I appreciate that. That being said, I'm certainly going to be a yes. And Senator, thank you for your openness to have conversations. I appreciate it.
Assemblywoman Anderson.
Thank you, Chair, and I'm so happy that the Vice Chair asked her question as well, because it gave me a chance to be able to think about the prior comment from somebody on the committee, and I would agree with him on, I believe the intent is that the first half of this information is really important for us to have. Still a little bit concerned about the eligibility issue, but I think the legal clarification took away some of my concerns, so I'll also be voting yes.
Assemblywoman LaRue Hatch.
Now my working. All right. The mic was just done. I hit my question limit. Okay, I echo my colleagues. I really am concerned at this idea of a fifth-year senior coming to play, because I think if you're a fifth-year senior, you need to be working on school and focusing on passing your classes. But I agree the other parts of this are important. So I hope that we can get rid of that part, which I hate, but I will still vote for the other part of it.
Thank you. And with that, I would take up. Oh my gosh. Okay. You're going to move. Okay. Assemblywoman Torres.
I still have concerns. I'm happy to speak to the bill sponsor. I haven't had the opportunity to, and I apologize for not having reached out earlier. But it's been kind of a whirlwind week as deadline is. I'm happy to continue having conversations, but I'm going to be a no today. Thank you.
Assemblywoman Thomas.
Thank you, and I didn't get a chance to speak with the sponsor. Sorry about that. I will be a no also, because I just do not like, quote unquote, the intent.
Thank you. And with that, I will take a motion to amend and do pass. Assemblywoman, I have a motion from Assemblymember De Silva and a second from Assemblymember Mosca. Any discussions on the motion? With that, all in favor say aye. Aye. Those opposed say nay. Raise your hand so I can count you. I have Torres and Thomas. Everybody else is a yes, so motion carries. And with that, I will assign this to Assemblywoman McHardy. McHardy. Which brings us to our next work session, which is SB 251. Ms. Drozdov.
Thank you, Chair. The next bill on work session is Senate Bill 251, which revises provisions relating to employees of school districts. The committee heard this measure on May 11th. Senate Bill 251 adds policies for the transfer and reassignment of school district employees who are not teachers to the mandatory scope of collective bargaining for a local government employer. The policies must include the transfer and reassignment of employees of a large school district, which has more than 100,000 pupils enrolled in its public schools during or in response to a reduction in workforce or in a surplus situation. Additionally, the bill provides that a large school district remains responsible for negotiating the policies for the transfer and reassignment of school district employees, including policies that provide placement rights to employees affected by a surplus situation and during or in response to a reduction in workforce. No amendments were proposed for this measure. Thank you, Chair.
Thank you. Members, are there any questions? Assemblywoman Hanson.
Thank you, Chair. I think we all remember there was a Supreme Court decision the morning of the day of the hearing that we had in the afternoon, and which ruled in favor of, I think, CCSD's lawsuit. Was that right? It's CCSD. And so my question is the bill really even needed? I mean, I know codifying it, but essentially it seems duplicative. I have issues with the policy, but I'm just curious why we're voting on it if the Supreme Court has kind of ruled on it.
Please go ahead.
Thank you, Madam Chair, Asher Killian, Committee Counsel. So I think it's accurate that this bill, in large part, given the Supreme Court decision that came out the morning of the hearing, simply codifies what the Supreme Court decided. As to whether that's necessary or not, that's more of a policy question that I can't really address. But I will say that this bill, as written, is consistent with that Supreme Court decision and would serve to include the core of that Supreme Court decision explicitly in NRS.
Madam Chair, if I could just follow up, thank you for that. So at this point, I'm going to be I'm having trouble with the policy, but I am open to learning more from those that know a lot more about this issue than I before we get a floor vote. But for now, I'm going to be a no. But thank you.
Thank you. Any other comments? All right. With that, I will take a motion to do pass. Assemblywoman Anderson has made the motion. Assemblywoman Torres has seconded. Any discussion on the motion? All in favor say aye. Aye. Those opposed say nay. Nay. Assemblywoman Hanson, Assemblyman MacArthur, and Assemblywoman Hardy. That's why I'm trying to say Assembly Member, because that's what we just need to do. So thank you. With that, motion carries. And I will assign that floor statement to anyone? Want to volunteer? All right, LaRue Hatch. All right. Next bill we have is Senate Bill 292. Ms. Drozdoff.
Thank you, Chair. The next bill on work session is Senate Bill 292, which revises provisions relating to school administrators. The committee heard this bill on May 2nd. Senate Bill 292 provides that principals are employed at will for the first 3 years of employment, and after those 3 years, a principal may be placed back on at-will status and subject to immediate dismissal if, in each of 2 consecutive school years, the school's rating is reduced and at least one half of the teachers request a transfer. If these events occur in any school year, mentoring must be provided to the principal and a survey of school conditions must be conducted. Additionally, the bill outlines certain entitlements of a principal who is reassigned. Senator Pazina submitted an amendment specifying that an at-will principal is subject to non-renewal upon recommendation of the superintendent and outlining certain conditions related to non-renewal. Additionally, Senator Pazina submitted an amendment changing the language in subsection 2A of section 2 from is reduced by 1 or more levels to is reduced by 1 or more levels or at the lowest level possible. Thank you, Chair.
Thank you. Members, do you have any questions? Assemblywoman Anderson.
Mine's more of a comment. I appreciated the response I received back from Senator Pacina about my concern. But I will be a no, as I continue to have concerns whenever we utilize scores, which is what the STAR system has as part of their ratings, test scores. So I will be voting no on this because I'm very uncomfortable anytime we utilize test scores as part of an evaluation process. It does not matter if it is a teacher or a principal, or for that matter, even a superintendent at some level. So, and that is, the school rating system does in fact use test scores in one area, so I will be a no because of it. If that language had been amended out, then I would have been a yes. So I'm hoping that maybe there can be some more discussion between now and the time it's on floor. Thank you.
Thank you. Assemblymember Thomas.
Thank you, Madam Chair. And thank you, Senator, for your amendment. But as I briefly explained to you, that this isn't personal. It's just that I agree with my colleague. I just see where this could be something that one party, the teachers, would be, the principals would not have the autonomy that they should have when they are governing their schools. So for me, it will be a hard no.
Assemblymember Lou Hatch.
Works now. Okay, fixed my mic. It wants me to speak again. Okay, I just want to echo my colleagues' concerns. I'm hopeful that we can work together in addressing those concerns. I was told that there's no opportunity for amendment, but we still have days left in the session, and I'm hoping we can work on it. I agree. I think if it's just based on star ratings, or if star ratings are included, that's problematic. I also think we're missing out a huge number of folks if we're not including people that are just quitting education entirely, if we're just looking at transfers. And so I will be a no now, but I'd love to work together to get to a yes on the floor.
Assemblymember Noska.
Thank you, Chair. I just wanted to thank the bill sponsor for working on this amendment. This actually addressed what I was concerned about, so I'll be a yes today.
Thank you. And I really want to stress what I take the policy in the bill is really the mentorship, right? I mean, we want people to succeed, and we want to give principals every opportunity to succeed. And so that, I hope will, everything else being said, and I appreciate all the teachers that are on this committee and the thoughtfulness when they go to use their voice and vote. So thank you for your work, and thank you for pushing that mentorship aspect. With that, I will take a motion to amend and to pass. Assemblymember De Silva has made the motion. Assemblywoman Torres has seconded. Any discussion on the motion? Okay, all in favor say aye. Aye. Those opposed say nay. Nay. And I believe it was LaRue Hatch, Thomas, and Anderson were nays, but motion does carry. And I will give that to Assemblymember De Silva, that floor statement. And next we have Senate Bill 340.
Thank you, Chair. The next bill on work session is Senate Bill 340, which revises provisions relating to education. The committee heard this measure on May 9th. Senate Bill 340 authorizes the Board of Trustees of each school district and the State Public Charter School Authority to use available resources to provide summer school, and requires these entities to submit a plan to provide in-person or virtual summer school to pupils in pre-kindergarten through grade 12 during the 2023 and 2024 calendar years. The Board of Trustees of a school district and the governing body of a charter school must also provide for transportation and meal services to these pupils. The bill outlines requirements relating to the hiring and payment of summer school personnel. Additionally, SB 340 requires school districts and the State Public Charter School Authority to submit a report relating to the plan to provide summer school to the Superintendent of Public Instruction. The superintendent must submit a compilation of these reports to various governmental entities, including the legislature. No amendments were proposed for this measure. Thank you, Chair.
Thank you, members. Are there any questions? Seeing none, I would take a motion to do pass. Vice Chair Taylor has made the motion. Do I have a second? Second from Assemblymember Thomas. Are there any discussion on the motion? Okay. Assemblymember Hanson.
Thank you, Madam Chair. And I appreciate the sponsor greatly. She puts up with a lot in the Senate. And I have my rural districts, and I've had some conversations, and some of those there at the local level, they have plans, they know their plans. And so I'm going to be a no at this point, but appreciate the effort.
Any other comments? And I just like to say, I think it's really important that we continue to look at that learning loss that so many of our kids were faced with. And so just any opportunity to get them back where they should be or ahead, I really appreciate it. And I know it's difficult to pull the stuff together, but we did it last time. I'm looking for the silver linings of COVID, and I think we learned that we could do things differently, that we've always done the same way, kind of forced us out of our comfort zone. So I'm excited, and Molly already knows this, but my daughter will be going to summer school. So with that, all in favor say aye. Aye. Those opposed say nay. And if you could raise your hands, we have Assemblymember Hanson, Koenig, MacArthur, and Hardy are no, and it does pass. And I will assign that to Assemblywoman Torres. You are welcome. Which brings us to our final bill, which is Senate Bill 442.
Thank you, Chair. The last bill on work session is Senate Bill 442, which enacts the Interstate Teacher Mobility Compact. The committee heard this bill on May 9th. Senate Bill 442 enacts the Interstate Teacher Mobility Compact, which establishes requirements for the issuance of a teacher license to an applicant who holds an equivalent license from another state that is also a member of the compact, and the sharing of files and information regarding the investigation and discipline of a teacher between member states. The bill requires the Commission on Professional Standards in Education to adopt regulations to carry out the provisions contained in the compact and provide for licensure pursuant to the compact. Additionally, SB 442 exempts a person who obtains licensure pursuant to the compact from the examination required for the initial licensing of teachers and other educational personnel. The bill also exempts a person who applies for a license under this compact from submitting proof with the application that he or she has completed an approved course of study or training. No amendments were proposed for this measure. Thank you, Chair.
Thank you, members. Are there any questions? With that, I would take a motion to amend and do pass from Assemblywoman. I will take a motion to do pass. That was Assemblymember Moscow. Second from Vice Chair Taylor. Any discussion on the motion? Seeing none, all in favor say aye. Aye. Opposed, nay. Motion carries, and I will take that floor statement. Okay, that we will close the work session, and that brings us to our last agenda item, which is public comment. Is there anyone here in Carson City wishing to make public comment? Anyone behind the pillar in Vegas wishing to make public comment? BPS, is there anyone on the phone lines wishing to make public comment?
Chair, the line is open and working, but there are no callers choosing to provide public comment at this time.
Okay, so let me just give you a lay of the land tomorrow. We do have an agenda posted for tomorrow's meeting as call of the chair. If there's any final business that the committee needs to conduct on our deadline day. At this time, it is not my intention of our committee to meet, but there's possibility, so we'll keep that agenda up and make sure that I keep the members informed of our plans. And this concludes our meeting for today. Meeting is adjourned.